Hi, it is me, Dean Burnetti again. I want to return to the subject about getting ready or getting you ready to give your deposition. In part 1 and part 2, I spoke about general rules both attorneys may discuss with you. Now I'm going to actually talk about some ways I approach preparing a client to give a deposition that may be a little different than other lawyers may do. Let me say that there are some common rules or guidelines all attorneys will share with their clients. Everyone is going to tell you to tell the truth. Everyone is going to tell you to answer your questions out loud, verbalize your responses. I want to note there are sometimes more than one deposition, though, is taken of you as a plaintiff. Later depos are often referred to as supplemental depos. In other words, attorneys can sometimes update your deposition, especially after several months have passed and you're coming up to a trial. For example, in a workers' compensation case, as many as 3 or 4 plus depositions may be taken of you during the course of your case. These are to update your testimony, to find out how you are doing and have your circumstances changed. You just want to make sure that you read your prior deposition transcripts to familiarize yourself with what you've already said before you go in and give another deposition. Also, in a civil case, make sure you read what we call your interrogatories, which are your written questions or responses to written questions that you've given under oath. But let me say, interrogatories are a part of the discovery process. It is important that you familiarize yourself with what you have already said in those before you give a deposition. I like to divide cases primarily into 2 different categories of non-jury versus jury trials. If I'm thinking about a jury trial, I'm thinking about you sitting someday in front of what I may find as 6, 7 strangers, the jurors that you are going to be telling your story to. They are going to be observing you, so it becomes important about how you present yourself to a jury. Jury appeal is something that is not spoken of a lot, but it is very important and a part of giving a deposition. I mean, let's face it, ultimately the jury is going to look at you, hear you, and going to try and decide whether you are deserving. One of the ways they do that is by assessing or deciding whether there is some association between you and them, whether they place themselves in their mind in your shoes, and in their mind imagine as if they had been there and that they had seen what it was like for you. That is the ultimate. That is what you want to occur, that you make a connection with the jurors by way of association and that they like you. It brings us to a fundamental. For you to have a jury appeal, the jury will ultimately hear what you have experienced. They will live in their minds what you've experienced. They will then be invested in you as a person. Once they are you invested, the only issue is what they're going to do for you. The way I approach it is, after I have given all my little rules and advice about the types of questions that will be asked, I get into the subject matter of jury appeal. One of the best ways I can describe it is that you want to present yourself as if you are at a job interview. If you are at a job interview, how would you act? Well, you're going to act at your very best. You're going to dress well, you're going to look clean, you're going to look groomed, you're going to look alert, you're going to be cheerful. And I always tell people you should be trustworthy, loyal, helpful, friendly, courteous, kind, and obedient, cheerful, thrifty, brave, clean, and reverent. In other words, you're going to be delightful. You want to be a model person. So think about how you would present yourself if you were sitting in front of someone giving you a job interview. Would you just say, yes, no, my name is Dean, yes, no? Would you be rather flat in terms of your affect? No. You would be talkative, you would be engaging, you would be talking about yourself, you would be looking at other things in the room about that person that is interviewing you and see if you could use something to make a connection. If the person has a picture of their children, tell them how wonderful or nice looking their children are. You may say, you have children, I have children. Anything that you can do to engage that association, to make that person feel when you left the room that, hey, this is a nice person. They would compliment my organization because they are like me. Believe it or not, that is important, that you present yourself wonderful and delightful, that you are a kind and courteous person. I can tell you it makes a difference. I know presentation makes a difference. Oftentimes attorneys tell clients just answer the questions and only answer the questions. My response is, if you were in that job interview, would you just answer the questions and shut up? No. You would just not say yes or no. You would be engaging. You would be talkative. You would almost be bordering on talking too much sometimes. Of course, you would not be rude. You would not interrupt anyone. You would not be talking over other people, but you definitely would be talking not only about yourself and your personal experiences, but also the things you love and do not love, etc., all in an effort to hopefully connect to the other person that is talking to you or interviewing you or observing you, the jury. So is the same with giving a deposition. You want to smile. I do not care if the other attorney is a butt. I do not care if they are disagreeable or condescending. That doesn't change who you are. You need to give them a sampling of what you're going to be like in front of a jury. It will make all the difference in the world. Now let's talk a little bit about non-jury depositions. In other words, depositions that may end up being read by a judge who will decide your case. It may be a workers' compensation judge. It may be that kind of matter. But regardless, I still think you need to do the same thing, and that is to be delightful and kind. At the same time, you have to be a little more calculated, that your answers are going to be read by a judge who's going to be wanting to cut through it all. So you want to be a little more direct and possibly bending more towards the idea of answering on point the question. I think that becomes a little more important to just answer or be directly on point in a brief, maybe more brief, with a judge than possibly a jury. You still want to come across as that kind and decent person who has a wonderful personality, who is courteous and polite, but at the same time, like I said, you have to be more protected about your answers because you know the judge is going to want to get to the point and get to the substance of your testimony. This is another reason why you need to go back and preserve at the end of your deposition, or with your attorney, have him preserve what I do for my clients, and that is the right for you to read and sign your deposition. I cannot tell you how important that is because people walk away and they think they said a certain thing a certain way and gave a certain answer, but when they read their testimony, it's not there. At least that preserves, by reading and signing, it preserves your right to read after it's typed up and make amendments or changes, whatever you need to do, and then you sign it. Until you sign it, it doesn't become final. So relax. If you make some mistake, hopefully you can fix it. At least this gets us ready for a deposition. People always have a lot of questions to ask about depositions. What they should say, or what should not say. What if they ask me this question? What if they ask me that question? I do not approach it that way. I think you can appreciate from what I have said. I am not into trying to predict every question they might ask you, because you would never be able to guess all the questions they can ask. But what I do is approach it from the standpoint of how do you answer any question with the appropriate attitude that will create a winning situation for you. Again, if you are in need of a lawyer to help you in a personal injury, slip and fall, auto accident, truck accident, motorcycle accident, workers' comp, medical malpractice, products liability, call me, Dean Burnetti. My cell is 863-899-3988. My office phone numbers are 863 or 813-BurnettiLaw. Visit me on the web at www.burnettilaw.com. Likewise, you can email me at dean@burnettilaw.com. My prayer is that God will bless you and your family. Again, Dean Burnetti Law, serving God and you.